going on? How's everyone doing?
Shout out to Colin and everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great night so far. Great day, great night, whichever one. Hopefully you had a great day. Happy Sunday. I've got a great show for you guys planned tonight. We are going to watch a prosecutor out of the state of Vermont. I got to say that right now. Out of the state of Vermont. This is not in Michigan. It's out of Vermont. A prosecutor that got a DUI driving to a crime scene that she wanted to do her own investigation on. So that's what we're about to watch. But because I don't know the ins and outs of the law, I requested help from a few friends. You guys want to meet those few friends? Here we go. We have Rob, Debbie. Hold on. There we go. That's the view I wanted. What is up, Rob and Debbie? How are you guys doing tonight?
Happy to be your phone a friend.
Yeah, thank you. Yeah. Rob, both of you know, whenever I have a legal question, I'm like, hey guys, do you have a quick second? I have a question that I don't know the answer to. I'm like, yeah, you guys pretty much are my text message punching bags when I'm clueless of what I'm about to talk about.
Well, happy to
But I
help.
appreciate
Similar answers.
Yeah. Before we do get started, for anyone who does not know, Rob, do you want to give? I know I just asked you to do this when I introduced you to backstage. Rob, you want to give a quick, I don't know, however long you want to introduce yourself for? Who are you? Where do you practice law? And how cool are you?
Not very cool. I'll start off with that one first. But
Liar.
I practice in Minnesota. I'm mostly criminal defense. I do some part-time public defense work. So I do quite a lot of public defense, helping indigent clients. Do help some private clients. I do pro bono immigration work and a little bit of civil rights litigation.
That is awesome. You've been crazy busy up there in Minnesota. I keep seeing you all over the news. So keep up the good work. I know you're stupid busy, but you're doing a great job. So keep it up. Debbie, I don't really need to introduce you. Everyone knows who you are.
Oh, I don't.
All right, but go ahead, Debbie. The floor is yours.
Oh, well, I wasn't prepared for this. I probably should have paid better attention. I'm a prosecuting attorney in St. Joseph County, Michigan. Former defense attorney and private practice attorney for about 14, 15, 16 years before I went to the prosecutor's office and then ran for the top position. And, I haven't done the pro bono work that you have, but hey, maybe governmental employment is kind of like pro bono a little bit. So
It's thankless all the same. So.
yes, it is.
That is a fair point. And thank you so much, mods. Both Rob and Debbie have their own YouTube channels, so thank you so much for sharing their links. Well,
mine has been so defunct, though. I feel terrible. Ever since January 1 of 25, got a little busy. So hopefully I'll get back to it.
You did get a little busy, and rightfully so. I mean, you worked your butt off, and you won a little thing called a political race, and now you have a lot more. I just
responsibilities. I mean, I don't know. It's just like there's a lot of responsibilities. There's a lot of overtime and on call, and I love it though. I truly love my job.
That is awesome, and we love seeing you every time that you're in front of Judge Middleton. I get a message every single time. Debbie's on. I'm like, all right, let's go watch Debbie. Stop what I'm doing.
I have such a good team that I don't have to step in there too often. But yeah, I mean, we all pitch in and wherever. So sometimes you'll see me. Sometimes I'll be in other courts. Sometimes I'll be doing all of the administrative fun that comes along with this.
The administrative fun.
Mm-hmm. We'll just call it that. We'll call it that.
We'll call it that. And I have to make this comment real quick because I know I told Debbie, I told you this right before, both of you, right before we started. The thumbnail, Debbie did not get a DUI. She did not. This video has nothing to do with Debbie. Her picture's on there because she's on panel. See, she's here. All right. I just had to make that clear.
No
real quick.
handcuffs. No handcuffs
No.
on. I'm here. I'm good.
All right. Well, you guys ready to jump into it?
Let's do this.
All right. So we are going to start with a little bit of body cam from the arrest. And so we have a little body cam from the arrest, a little body cam from or maybe security footage from the actual police station, and then I've got a little clip of a local news story that was played. So we're gonna start with that just to give you guys a kind of a high level overview of what's going on before we get into the actual disciplinary hearing we're here for. So let's go. Oh, and as always, Rob, Debbie, if you have a comment, just say stop and I'll hit pause.
Or I'll just start talking. That's usually
Or
my
just start talking
go-to.
and I'll pause it anyways. That works too. All right, let's go.
So I know that you told Chip and Lemna that you had one drink. What was it? About an hour or so ago. Okay. So some of the things that I'm seeing is that you're slurring your words a little bit, and that you this strong smell of alcohol coming from your breath in the person. So before you head out of here, I'm gonna ask you to step out and run the sobriety test. Okay. So if it's no, then I'm gonna ask you to step out and do the arrest or suspension of DUI.
Really hard to hear her.
No, that's not an option. I wouldn't allow that to anybody else.
Yeah, you can't really hear it very well. The subtitles will help you a little. I mean, they're on the road.
What
But,
did he just say that he then responded like we wouldn't do that for anybody else?
Let's rewind. Let's see if we can read the subtitles. I don't know. That might
I
be
don't think
important.
that I have the subtitles for her, but I could be wrong.
Maybe. I don't know. All right, let's just go back here.
Okay. So some of the things that I'm seeing is that you're slurring your words a little bit, and that you this strong smell of alcohol coming from your breath in the person. So before you head out of here, I'm gonna ask you to step out and run the sobriety test. Okay. So if it's no, then I'm gonna ask you to step out and do the arrest or suspension of DUI. No, that's not an option. I wouldn't allow that to anybody else.
Yeah, it's illegible. We have no idea what she said. Now,
Maybe it's because he's slurring her words.
that could be. Now, during the disciplinary hearing, that we're about to watch, they reference this a lot, so they might actually say exactly what she said because it comes out a lot what she asked / demanded the police officers to do.
So the option is
It doesn't matter if I do the test or not. However I perform, he's going to take me under arrest.
So, Eva, that's not true.
It is
Okay.
true.
So
I've seen
what I
that.
need you to do is either step out and do the test, or you're going to be under arrest. It's entirely up to you.
I'm taking the risk.
Go over to that cruiser then.
So we'll say, and maybe Rob, you can weigh in on that. Typically, if it's your own county's prosecutor or your city's prosecutor, and then they would call in an outside agency, like Michigan State Police in this instance. But looks like this is just the people that were on the scene already doing the investigation. Is that accurate, Colin?
Yeah, as far as I know, that's exactly what's going on. Is they smelled alcohol on her breath while she was walking around the scene, and when she left, that's when they pulled her over.
Okay.
So I don't know what jurisdiction. I don't know. So I mean, I
Well,
don't really
if,
know
if
how
she's
that
the
works.
one that's there kind of assisting with the investigation as much as the prosecutors are permitted to, I would assume it's like one of her agencies. So
Yeah, that would
that's
make
got to
sense.
be a little awkward for all of them.
Yeah, it might make more sense to have like Vermont State Police or something like that come take over the investigation just to remove any of that impropriety. But for both ways, any favor that the police might show the prosecutor or any prejudice.
Mm-hmm.
Yeah, I do want to make one point real quick. I love that Rob has said more than one time, never ever take field sobriety tests. Don't do it. And when you see a prosecutor refusing the test, I think that speaks volumes to what Rob's been saying. Neither one of you have to comment on that. Just kind of, paying attention. Real quick, I know I've got a lot. I'm gonna pause it for super chats and gifted memberships throughout the video. So don't feel discouraged if I don't click you right away. But this is super generous. Legal Fiction, thank you so much for your 20 gifted memberships. You are awesome. Welcome to the 20 new members. Legal Fiction, thank you so much. Okay, I just wanted to make sure to shut that out real quick. Let's go.
Is there somebody we can call to come get your car, Eva? Cheryl Vogue. Okay. Go ahead and separate your feet just a little bit. You don't have any weapons on you, right?
All right, ma'am, I'm going to double lock you so that they don't get any tighter when you sit back in the car, okay?
Is your cell phone in your car?
Just complying with the lawful commands of the officer.
Some of the things that I'm seeing.
Always a good start.
Yeah.
You don't want to escalate it into a resisting and obstructing or something like that. So we see those often.
Yeah. Maybe this is going to be. They're looking back in her car now. So this is the news story. We just moved to the news story. Okay. I was going to say maybe they're going to heighten the audio so we can hear it, but now you see the news logo at the bottom. We're about to change angles a little bit. The news is going to tell us what just happened, I guess.
Is that discerning your words a little bit?
The January 2024 video shows Addison County State's Attorney Eva Vakos responding to the scene of a homicide. A trooper claiming he could smell alcohol on her breath asks her to do field sobriety tests, warning a no would mean an arrest, to which Vakos responds, "Are you serious?" She refuses to do the tests. The county's top prosecutor was soon after handcuffed and put in the back of a cruiser. She was then taken to the state police barracks in New Haven and placed into a holding cell before a sergeant who came up from Rutland began the processing. Vakos suggested he could use his discretion and said she didn't want her mugshot taken.
No photographs.
Okay.
My face is not going to go out in the paper.
That's again nothing that I'm going to decide. So as far as discretion, we as a department don't take any discretion with DUI. So
there wasn't any DUI. There was alcohol in the breath.
Okay.
And alleged slurred speech.
Okay. Yep.
So.
Which are enough indicators to request an evidentiary test, which you know as the state's attorney.
That's great. We've been working really hard with law enforcement to build a good relationship.
Okay.
And this is gonna knock that really down. And really, my office is gonna suffer now.
The prosecutor went on to say she was doing her job by going to the scene of a crime.
And I guess that's where maybe your discretion would have been better used.
In what way?
Well, if you knew you had a drink or two.
An hour ago. An hour ago.
So.
With a meal.
Okay. Then.
Doesn't make me inebriated. Doesn't make me impaired.
I'm not, based on my training experience, there's enough indicators.
Vakos told the sergeant she wouldn't answer questions or make statements and knew a 6-month license suspension would be coming. She wanted photos of her wrists where she had been cuffed and briefly sobbed while calling a...
Oh, I thought I cut that last part out. We don't need to see her crying. So we'll skip over that part. All right. What do you guys think of what just happened?
Do you want to go first?
I know Rob had his finger up a few times, so I feel like he has comments.
So, I mean, basically, she decided. So, I don't know of any states, maybe there are. So, this certainly isn't legal advice, but it's generally not a crime to refuse to do the field sobriety tests. I say that I would never recommend submitting to them because generally the officer has already made a determination of whether or not you're intoxicated at that point. So, you're basically just testifying against yourself. I've heard of one instance out of the thousands of DWIs that I've seen where somebody's done the field sobriety test and then the officer says, you know what, I think you're okay, you can go on. Usually it works the other way where you're only just building evidence against yourself. But it sounds like what she did is she actually refused the post-arrest test, which in most states is part of the implied consent. So when you sign up your driver's license, you're agreeing that once you're under arrest, if there's probable cause that you're intoxicated, you have to submit a chemical breath test, not the breathalyzer on the roadside, but the actual, ours is Data Master. Some other states have other things that at the station, the calibrated scientific machine, you're agreeing to submit to that. Now, refusing to do so generally means that you lose your license privileges. So it looks like she chose to do that. So, so she elected to lose her license rather than give a scientific breath test sample. So that's interesting. So she's definitely likely has a crime for DWI refusal there. I don't know what her charges were, probably misdemeanor. But she elected not to give any evidence against herself. But then the part that really concerns me is when she said, that, well, hey, we've worked really hard to build a good relationship with your department. Now that's going to be tainted. I hear that as, if you don't give me preferential treatment, then we're not going to have a good relationship anymore. And that's extremely problematic.
And that's how this entire panel of lawyers saw that too. Well, besides the people that defended her, that's about what we're about to watch. So,
So
Debbie, real quick.
I will say I disagree respectfully, Rob, with these field sobriety tests. We've had lots of cases. Now, I guess I gotta preface this. I see cases that don't end up getting tickets, right? They send it in as a warrant request. Rob is seeing the cases that a prosecutor already looked at it and has issued the warrant, or the officer issued the ticket. So it's different on my perspective because I see lots of cases where they do comply and they are fine. Sometimes it's a medical issue. Sometimes they're just tired. Sometimes it's just the officer thought they smelled alcohol and it wasn't. So I always recommend that you do the standardized field sobriety test. We have the Intoxilizer 9000, which sounds super special. It has replaced the Data Master. But a lot of times, if you're going to refuse, then it's going to go to a blood draw, and a blood draw may reveal more than just alcohol in your system, which could be more problematic for you than just taking the Intoxilizer. So, in Michigan, implied consent is a 1-year hard suspension. So, I guess she only has to be suspended for 6 months. Hopefully, she has some good public transportation. You can fight that in Michigan anyway. It's an administrative hearing through the Secretary of State, but it's the probable cause to have you take it. It's pretty hard to refute probable cause on these types of cases. So, she does have the opportunity, I suppose, to have that hearing if she were to choose to.
So I've got a question, and I don't know if either one of you can answer this. That this actually might come as a form of legal advice, and if it is, do not answer that whatsoever. But if you refuse everything, you don't get a warrant for your blood, so you just refuse everything, and you get the automatic suspension for refusing the test, and then the DUI gets dismissed. Does that actually work in your favor to get the automatic suspension overturned?
It does not.
So it's automatic regardless. The second you say no, it's like, yep, your license is suspended for 6 months or a year, depending on where you are. Even if you beat the DUI, your license is still suspended for that period of time.
Correct, because your burden of proof is different. So to be found guilty of the criminal offense, it's a beyond a reasonable doubt standard, so as high as the standard goes. Whereas, if you're trying to refute the probable cause, it's like the officer only has to have a teeny bit of information to form that probable cause, reasonable suspicion. And in this, she admitted to drinking, so it's not, it'd be different if she's like said nothing or hadn't been drinking, didn't make any admissions, but sounds like she made some admissions. And then, yes, you never use your title or your relationship with law enforcement to try to influence what somebody's doing with your personal case.
Yeah, I went on a ride along like 6 years ago. Like they should treat me better.
Yeah.
In Minnesota, the Department of Public Safety handles your licenses completely separate from the courts. The courts can't take your license. The courts can't give you your license back. So, if you refuse it, it's an implied consent advisory, automatic 6 month to 12 month, depending on the circumstances. Suspension of your license, and there's nothing you can do to get it back. You can apply for a work permit so you can get to and from work, but all of that's handled outside of the courts. It's 100% administrative within the Department of Public Safety.
Okay. Are more states like that? I don't know how to phrase the question I'm asking.
So typically, the license to drive is a privilege, not a right, and so it's an administrative.
We travel around here. We don't drive, so don't worry.
Yeah, right. So
Free man on the land.
It's similar in Michigan as far as the Secretary of State and the administrative process for your driver's license. However, certain crimes do trigger the court to that and issue an order that is sent to the Secretary of State that your license is suspended, revoked, denied, whatever. There are ways, though, for the court to to supersede that, I guess I'll say. Like if you have multiple DUIs and you are in a sobriety court treatment program, the court can issue a restricted license even if the Secretary of State had suspended or revoked your license.
Fair enough. All right. Before we start this disciplinary hearing, I'm going to catch up on the super chats real quick. So this is just going to take a minute. Jedi, hey, Rob. I got to do the voice every single time, Rob. You know that. And Thor says, hey, Rob, too. She couldn't be here tonight. Thank you so much, Jedi, for that. Alan, thank you so much for the 5 gifted memberships. I appreciate it. Welcome to the 5 new members. Alan, you're awesome. Otto, wow, I thought you were lying about getting Debbie on your channel. My apologies. Yeah, no, I don't clickbait. Apparently, all I do is make people think that Debbie got a DUI, but no, she's here. She's here. That's why her picture's on the thumbnail. But I will have to change the thumbnail after tonight's stream, which will happen because we don't want Debbie. We don't want rumors spreading about Debbie. But she's here. Otto, thank you so much for that. Legal Fiction, thanks again for that very generous 20 gifted memberships. I appreciate it. And Cheshire Cat, never fear trouble is here. And hello, Debbie Davis. Cheshire Cat, good to see you. All right, now we're going to start the disciplinary hearing. Just a quick jump because what I just showed you happened over 2 years ago. So we are in front of a disciplinary committee now. She pled no contest after fighting that DUI for a year and a half. So she fought it. She eventually pled no contest. I don't know what her actual punishment was or her sentence was. I don't know. But this is we're in front of the disciplinary committee because they suspended her license. They suspended her license to practice law in the state of Vermont about a year before this hearing because of pretty much what we saw. This committee thought that she was, using her position as a way to get out of a DUI. I don't know a better way to say that. There's probably a much more professional way to say that, but her license was suspended. So now we're back in front of the court to see if it's going to be if they're going to give her license back to practice or if they're going to continue to keep it suspended. I think that's the best way I can put it. Okay. Let's go.
Good afternoon, Your Honors. The matter before the court this afternoon is the case entitled In Re Eva Vacos, case number 26 AP 081. Representing the petitioner, the Office of Disciplinary Counsel, is Attorney John Alexander. Representing the respondent, Eva Vacos, is Attorney David Slay.
Okay, thanks very much, and good afternoon, counsel. We'll hear from disciplinary counsel first. Please start by introducing yourself, identify your client, and then proceed.
Good afternoon. John Alexander, Disciplinary Counsel, representing the petitioner, Office of Disciplinary Counsel.
Thank you.
Thank you. May it please the court. The question presented by the petition for interim suspension before the court is whether the December 2025 misdemeanor criminal conviction of the respondent, State's Attorney Eva Vekos, for driving under the influence, first offense, is in violation of 23 VSA 1201A2, constitutes a quote unquote serious crime as defined under Rule 21 of the court's Administrative Order 9. It is our contention that respondent's DUI conviction does constitute a serious crime as that term is defined under Rule 21, because the state's attorney's criminal conduct, in light of the circumstances surrounding its commission, reflects adversely on respondent's fitness to practice law as a criminal prosecutor in respects other than her honesty or trustworthiness. Specifically, respondent's pattern of criminal and other professional misconduct on the night of January 25th, 2024 reflects adversely on her respect for her legal obligations, which is a characteristic just as relevant and essential to an attorney's fitness to practice law as honesty or trustworthiness.
Well, she wasn't charged with a felony, right? There's no felony here.
That is correct, Chief Justice. She was charged with and convicted of a misdemeanor, that is driving under the influence first offense. And the petition certainly does not contend that any first-time misdemeanor criminal offense reflects adversely on fitness to practice law. Rather, the nature of this misdemeanor criminal defense, and perhaps just as importantly, the surrounding circumstances, the aggravating circumstances of its commission and the aftermath, indicate that State's Attorney Vekos is indifferent to her legal obligations and lacks the characteristics needed for law practice, specifically as a criminal prosecutor.
Well,
Alexander,
I'm sorry. Go ahead, Justice, please.
Please, Chief. Counsel, how far? Oh, go ahead.
No, you go ahead. That's all right.
All right, Counsel, how far out is the net that you're casting? Because it's a.
Yeah, is it bad when you have about 12 people that want to jump in on one point? I mean, I don't know. I feel like everyone had something to say about that.
So I guess I'm looking at this on their perspective that not only did she make a very poor decision to consume any amount of alcohol and get behind the wheel, but as the prosecuting attorney, she went to the scene of a homicide, which, you know, the risk of tainting evidence or causing issues that would then, you know, be an issue with the criminal case for the homicide, because you made a poor decision to drink and drive and then not just go home, but like go to the scene of a crime that's being investigated. And then aggravating it further, you tried to use your position to get out of it, and you tried to, skirt the system. It honestly sounds like what they would have preferred is if she would have been pulled over for poor driving or whatever, and they suspected DUI. And if she was, yeah, I was drinking, let me do your tests and we'll see, that she probably wouldn't be in this position where she's at.
Yeah.
I think, well, to your first question, like being in front of courts of appeals or Supreme Courts, they're always interrupting each other anyways. I can't, like, this is amplified by like 5 times on Zoom. So that's kind of interesting. I couldn't imagine trying to do an appellate hearing on Zoom. That sounds awful.
And the transcript is probably just as bad.
Probably.
Right. But to Debbie's point, like that's I got 2 points here. One is bad decision making as part of a prosecutor. But what I'm struggling with here, and I'm interesting to see, is to what level do they hold a prosecutor as far as an ethical violation different than any other attorney? Are they applying the same standards for every attorney, or are they going to have a separate set of standards for a prosecutor? That's what I'm going to be interested in as this unfolds, because I think that prosecutor should be held to a higher standard within the legal system because of their position. But is the remedy for that being treated harshly as part of an ethics review, or is the remedy that something political because of the elected position? That's going to be interesting if they are applying the same standard to a prosecutor as any other attorney who got a DWI.
That's fair. I'm not going to spoil it for you. I'm not going to tell you what happens. Real quick, Phil, thank you so much for the 5 Get the memberships. You are awesome, Phil. Welcome to the 5 new members. Thank you, Phil. All right, let's keep going.
That there were certain statements made several days after the event. Are you intending to rely on those as part of your theory here that this is a serious crime?
I believe what the justice alludes to is State's Attorney Vakos's email correspondence, I think about a week after the night of her arrest, in which she indicated to law enforcement leaders in Addison County that she did not feel safe around law enforcement and therefore would not be meeting in person with them, would not be doing scheduled trainings. And so I offered that factual circumstance as really corroborative proof for the validity of what I contend was a very thinly veiled threat made on the night of her arrest in the processing room of the New Haven Barracks to Sergeant Neary, in which she indicated that this by which she meant her arrest and imminent citation for DUI, was going to damage her office's relationship with local law enforcement, and that her office being the Addison County State's Attorney's Office. And so to more directly address the justice's question, I'm not casting a wide net. I'm not trying to look at alleged conduct that has no relation at all to the criminal conviction. What the authorities seem to indicate, both within Vermont and outside of Vermont, is that for certain criminal offenses, it is not sufficient to consider the criminal conviction in the abstract or in a factual vacuum. Rather, for certain criminal offenses that may or may not adversely affect on fitness to practice law, the tribunal must look to the surrounding circumstances. And it's our contention that one of the most important surrounding circumstances is how State's Attorney Vakos reacted on the night of her arrest in her interactions with law enforcement personnel. It's quite apparent that State's Attorney Vakos was making a plea for leniency, but linking that plea for leniency to her status and position as the chief law enforcement officer of Addison County. And that in itself is an independent ethical violation. It's interference with, it's prejudice to the administration of justice. And
related to this, Attorney Alexander, do you think that there is a different standard or a different body of case law that should apply when a prosecutor or another public servant commits a crime? Do you think that the analysis of what is a serious crime, reflecting adversely on the fitness to practice, do you think the threshold is lower when a prosecutor is involved?
I do. I do, Your Honor, Justice Nolan, because just to the point I was making earlier, that when assessing whether certain crimes committed by lawyers are serious crimes, one must look at the relevant surrounding circumstances. And the authorities from outside Vermont, including in particular the In re Oliver case from Indiana, indicates that one relevant factor is the attorney in question's area of legal practice. And it cites as a specific example, there was a Indiana prosecutor who was convicted of domestic battery on his wife. And the case cited there said, well, given that the prosecutor has been convicted of domestic battery, it raises a very reasonable question as to whether that prosecutor can zealously prosecute domestic assault cases anymore.
I saw that case, but I noticed that there are some listed offenses that clearly qualify, and violence is one of them. But do you have a case? I looked at a lot of the cases. Do you have a case where it's a single first-time misdemeanor DUI with all conditions complied with, including alcohol programming, no recidivism or prior offenses, anywhere where interim suspension was granted for such an offense?
It's a good question. Good question. This is a justice that's on. Well, I'm not going to say she's on the side of the prosecutor, but at least you have a justice that's leaning that way, which is good. And no, the attorney is not here for this hearing. She doesn't have to be. Her attorney is. So that's all you need. I think David Slay, the guy in the top middle, is her attorney, if I remember correctly. Debbie, Rob, any comments before I hit the play button?
No, I mean, it is interesting the way that the one justice is framing it, because there is an expectation that with prosecution, we're making judgment calls about, who to prosecute and who not to. We have different standards in the ethical rules than what defense attorneys do. Defense attorneys can zealously advocate, and that's really not what prosecutors are required to do. We have to zealously advocate for justice, not just to get the conviction. And with defense, they can do more things and plant ideas that they don't necessarily have any evidence to present regarding the alternative theory. We can't do that. So I think there is, unfortunately, for us, a higher standard.
Yeah, Debbie's absolutely right there. I know the Department of Justice has this standard. I assume many states does, Minnesota does, but the actual prosecutor themselves has to have a belief that, beyond a reasonable doubt that the person committed the offense. I don't have to have a reasonable belief that my client didn't. I required, ethically bound, to represent them to the best of my abilities, even if I think that they're guilty of the offense. Whereas Debbie's on the opposite side. If she doesn't think that they're actually guilty, she's ethically bound not to prosecute that case.
Or to seek like an overturning or the conviction after. I mean, sometimes it's years later when a victim comes forward and maybe they say, hey, this didn't happen. We are ethically obligated to follow up with that. So it's a very different, unique area of the law to be in prosecution.
Fair enough. You guys are awesome. Thank you so much. Your input is amazing. Both of you together, it just works. All right.
Dream team.
I do not, Justice Nolan. The case presented here is, in certain respects, unique. The case that comes to mind that was discussed in my petition, the People v. Miller decision from Colorado, that was a first-time misdemeanor DUI conviction, I believe, although the court, the majority opinion, cited some additional aggravating circumstances that it believed made not interim suspension, but basically finding a violation of Rule of Professional Conduct 8.4b for a serious crime.
So, Mr. Alexander, just again, following up on Justice Eaton's question, I'm not sure you fully answered that, but when you talk about the aggravating factors, you're specifically referring to abuse of authority, correct? More or less, all this comes under the ambit of abuse of authority. Given her status as a state's attorney, as you identified, the primary law enforcement officer, in the course of an investigation in her role as a state's attorney, she attempted to use her authority to get leniency or a better result with the allegations of the trooper for the DUI.
Yes, Justice Waples. Those are two of the most important aggravating surrounding circumstances. The fact that in trying to evade responsibility for her criminal conduct of DUI, she attempts to leverage her public position as state's attorney to gain leniency. I think there's also indications in Sergeant Neary's affidavit and the video from the processing room that it was almost as if State's Attorney Vacos was purporting to give Sergeant Neary legal advice and legal guidance on, well, do you know that you can use discretion to simply turn a blind eye to all this? So that is in my contention, that is a highly aggravating circumstance directly related to the criminal conviction, that she's trying to evade citation and prosecution by leveraging her public position as state's attorney, as well as her professional status as an attorney who can give legal advice and legal guidance.
And then 1 week later, she then sent an email where she told the major primary law enforcement officers in the county that she was fearful of her safety a week later. Is that correct? It's a week later.
Right.
Okay.
And
she couldn't work with them. Is that right? That she could not work with them, she thought or felt.
That was the implication of her emails. I should note in complete fairness that State's Attorney Vacos apologized fairly soon after making these statements that I don't feel safe around law enforcement and I can't do these trainings. So I think there is evidence that she, after being essentially called out on her conduct, I believe by a lieutenant in the state police, she apologized. I don't know if
well, that is included. That is included.
Yes.
All right, this is actually a great time to pause. Cynthia, what we're watching right now is we have an elected prosecutor, not Debbie Davis. I feel like I have to say that every time now.
Thanks.
Yeah, we're in Vermont. We're not in Michigan. We're in Vermont. But an elected prosecutor got arrested for a DUI, and she kind of, I'm not going to say she did. She kind of alluded to the fact that she's a prosecutor and the police should just let her go. We saw a snippet of the video. She didn't outright say it, but she kind of did. But I'm not gonna make any arguments there because we didn't see the entire video. That's what we're watching right now, and we have Debbie and Rob on panel, which is awesome. I had something to say and I forgot. I completely lost. Oh, Debbie, it is definitely not good for a prosecutor to say I'm afraid of the police. I can't work with them. Am I wrong there? Like, it's a terrible thing to say as a prosecutor.
That's accurate. I was trying to figure out where that fear, I guess, was coming from. It's not like she accused one of them of assaulting her or, unreasonable excessive force was used against her. So I truly don't get, I don't know if it was more of a, I don't feel safe around you. Like you guys are going to skewer me or humiliate me. So I don't feel safe to be around you, but physically safe, that seems very strange. Emotionally safe, yeah, it's probably super embarrassing. But it is what it is. So I guess I don't understand what her reasoning was for claiming that she couldn't do trainings with them. Like, was she leading the training or being a part of the training? I'm not quite sure.
Yeah, I mean, if it's just a sense of embarrassment that you don't, that's a weird choice of words to say that I don't feel safe. That at least to me,
Right.
just in plain speak, implies like physical safety or or security, that you fear repercussions from working with them, not just embarrassment. So it's an odd choice of words, but to her credit, it does sound like she apologized shortly after. I'd like to know how shortly is, but I doubt we're going to get that from this attorney.
He said within a week. She apologized within a week. I believe that's what he said.
I thought it was she
Okay.
sent the email like a week after, but at any rate, it's a very straight. It's not like she's prosecuting a police officer who is, the supervisor of all these other officers that she has to be around, and like she thinks they're going to do something. Again, they're all bound by ethical rules as well. So you should be able to feel safe around police officers. That's kind of a cornerstone of what you need to have as far as a relationship with law enforcement.
Yeah, I mean, I don't know how Vermont works, but Michigan, you work hand in hand with the police. Like they bring you, hey, this is what happened. Can you please charge this person? Like you have to have a good relationship. Like, right? Am I wrong? So
No, I
saying
mean,
that's
that's
not a great
accurate.
thing to say.
No, and the
Well,
thing is, go ahead, Rob, you can take
oh
this
no, I
one.
was just, when I worked in law enforcement, our sheriff's department had a very tumultuous relationship with the prosecutors. So there are some dynamics that happen where, you know, a lot of times detectives and deputies would feel like they did a lot of work on something, brought it to a prosecutor, and then things got turned down. That's not the case here, but they should have a good working relationship, but that's not always the case with every agency and prosecutor's office.
That's fair.
Yeah, and that's exactly what I was going to say. It's difficult because, yes, we're on the same team as far as wanting to seek justice, right? But we also, the prosecutor has the final call, and there's certain evidentiary standards that might not have been met. And it's difficult to tell a police officer or a group of them that, hey, I know you worked really hard on this, and I believe that this person did it. But for X, Y, and Z reasons, I don't believe that we can prove this beyond a reasonable doubt with the evidence that is going to be admissible. Because there's always evidence of other things. There's hearsay, but does it meet the standard to come in? If it doesn't, we can't use it. So again, even with like sexual assault cases, wait, I'm not supposed to say that on the live stream. SA cases, you know, there's times where we 100% believe the victim. We believe that this person did it to them, but there's not sufficient admissible evidence. And that's a tough thing for law enforcement and prosecutors both.
That's fair.
Well, and I can tell when I get those cases where the prosecutor was pressured to bring in a crappy case just to satisfy, you know, law enforcement, where they could say that they tried. Because I look and I'm like, I'm going to get this tossed at a contested hearing. What are you doing? And, you know, sure enough, I get it tossed. But, you know, I believe, and I'm not going to impugn any prosecutors, that they were pressured to continue with a bad case in order to try to maintain a relationship with a law enforcement agency, which, you know, I don't think was necessarily unethical. I think that, you know, it was at least viable. It wasn't something that was completely out of the question. So I'm not thinking there's any ethical violations, but sometimes there is a tumultuous relationship where prosecutors feel pressured to push for something that, you know, maybe they're not confident will survive a challenge. And on the other side, law enforcement has a lot of unjustified anger or, you know, upset feelings at prosecutors because the evidence just isn't there, and because they know with what they've seen that they're convinced beyond a reasonable doubt. But you know, to quote a law-abiding citizen, it's not what you know, it's what you can prove in court.
Good one.
Great movie.
Well, and also just to kind of piggyback off of that, prosecutors are ethically bound to not just go forward with a case because of law enforcement pressure. And, you know, that's obviously an issue if the defense attorney is feeling like that is what has happened. And it does cause hard feelings sometimes between the prosecution and law enforcement. You know, and there's times where one of my APAs may make a decision and I look at it differently. We're human, and we're certainly willing to look at, you know, what you have and give you some advice on, look, this is or this isn't. If you want to go do follow-up and something comes out of it, we're happy to take a look at it again. And that usually is the best way that we found to handle those questionable cases. And sometimes the follow-up is like, yeah, it wasn't, or this isn't provable beyond a reasonable doubt.
Fair enough.
They say prosecutors are the first defense attorneys. So there you go, Rob.
It's true.
It's true. Because just charging somebody can ruin their life. Just accusing somebody of something can ruin their reputation. So we take it very seriously.
Which is why we have good people in those positions, or at least hope to, like Debbie.
Oh, I can't speak for that, but thank you. You know, I just do my best that I can.
I've known you for a while. You're a good person, and I completely trust. I've trust in you that you are doing the absolute best at your job that you possibly can, and you don't have to say anything else, because I'm not going to let you. We're going to move on a little bit. Lisette, thank you so much for becoming. You're not a new member, Lisette. I know you probably actually have a milestone here, but Lisette, thank you so much. German juror, if it's a crime to drink and drive and then trundle graciously across a homicide scene, lock me up. Oh, you've done that before. You probably shouldn't put that on the internet, especially not in a super chat. But yeah, German juror, you might have a warrant for your arrest. I do appreciate the super chat though.
Sorry,
Vic.
I thought this was America.
Yeah. George, I understood that was a joke, by the way. I just was trying to, give a little anticipation to it. Not anticipation. That was not the right word, but let's move on. Vic, thank you so much for the super chat. Debbie, we need some goats and crazy birds. I hope all is well after the tornado.
We survived. Unfortunately, there were some that did not, and it's been tough, but also really a beautiful community coming together with Cass and St. Joe and Branch counties and people from all over the United States helping. So personally, I'm good. My family and friends are good, but some of our neighbors are hurting. So thank you for that. And my daughter brought me a sparkling juice because I am dying right now, and my dog is in here now. So Chief is laying by my feet. So
Chief,
Chiefers.
that was nice of that was nice that you had a beverage delivery, but
Yes,
yeah,
it is not alcohol, non-alcoholic.
it does kind of look like a Mike's Hard Lemonade can. I'm not gonna
It
lie,
kind of
it does
does.
kind of.
One of the kids at my kids' school was like, "Are you drinking alcohol at the game? Like, what are you? No, this is sparkling juice. Like, I don't really drink anymore, honestly. It's just things like this, right? Like, it's not really worth it. So
Yeah, I agree. It is not worth it. Alex, thank you so much for the 10 months. I appreciate it. Good to see you, Alex. And double clicked it. Heidi Mary. Hopefully, I said that right. Alive with Debbie Davis is it's my happy day. Yay, Debbie Davis is here. Yay.
I'm glad I said yes, Colin. This was fun.
I'm glad you said yes too. And Rob, it's good that you're here too.
Yeah, Rob, good to have you too. Nice to meet you.
Allegedly.
Rob is awesome. Rob is awesome, but the entire chat knows him. He's here all the time, hanging out in the chat. So I think it's less of a shock that he's here and more of a shock that you're here. So I don't think Rob's taking offense to it. Okay, well, let's keep going.
In your email stream.
Right.
Her apology.
Her apology, but
Yes.
I think what I was maybe inartfully trying to explain to Justice Eden is I think that looking to her conduct 6 days later, normally I would not do that because it's sort of removed in time and connection to the actual criminal conduct, but it sort of corroborates the threat she made in the processing room on the night of her arrest to Sergeant Neary that, well, this is really going to damage my office and its relationship with law enforcement. And it was a direct allusion to the fact that she controls the Addison County State's Attorney's Office and implying that she would use that authority to sort of retaliate or to try to get leniency for herself in a personal criminal matter. I should also note there are a couple other aggravating factors in my view that are directly linked to the criminal conviction. And that, number one, it's almost obvious, is that unlike many other attorneys who are convicted of crimes, State's Attorney Vacos committed her crime directly in the course of her work as a lawyer. She drove intoxicated to a work function, specifically the walkthrough of this potential crime scene, knowing that she was going to meet with law enforcement officers, knowing, I would say, that a prosecutor who conducts a walkthrough of a crime scene has to have a clear head to do their job effectively. And so
let me ask about that. Do you take the position that a prosecutor is always on duty?
Potentially, yes. Now,
yes,
I should be clear. It's certainly not a crime or a disciplinary violation.
And that's a good question, and one that has some merit. If she wasn't planning on going to this crime scene and she had a drink with dinner, I mean, is that a crime? I mean, the police thought that she smelled enough of alcohol to make it a crime, but it's a good point.
Yeah, I mean, we are on 24/7. Like it's in our job description for even the APAs. Now that doesn't mean that we can't have a life, we can't travel or that sort of thing, but you have to make sure that there's somebody that is safe, sober, available to answer phone calls. And so, we don't get extra pay for on call, so I don't ask my assistants to do it at this point. We're working on some of that because I don't think it's necessarily fair to them. But they know that if something were to happen to me, I'm out of town or unavailable, they go down the chain, and if a prosecutor is needed, then somebody has got to be available. So yeah, unfortunately, it's one of the things that we are on call 24/7.
Yeah, I mean, it's the decision to get in your car and go to the scene is the issue, not that she decided to have a drink, So I think not having a plan in place to where, okay, I'm going out tonight, so I need to have one or two people ready to, if the situation arises, to take over for me. I think that's perfectly fine. I certainly don't expect a prosecutor to forego having a social life for their term of their service. But the bad decision to get into the car and to go to the scene, I think that's the big issue.
And I will say it's discretionary whether you go to a scene or not. It's not every time by any means. I mean, that would be crazy. But there are times where we do choose to go to the scene. There was one where it was a fatality, traffic crash, and it was unique. And so I went while the accident reconstructionists were working on it. And you learn a lot. Everybody has like their special niche, whatever. And being there and seeing how they find these just tiny little clues and put them all together and how it's done makes you a better attorney, makes you a better prosecutor in presenting this evidence in a trial later on. So I think there's definitely value to going to the scene, but you can't, there's no value to going to a scene if you've been drinking like that. So that's
Yeah, I agree with that. Could she have called someone else? Like, hey, I had a glass of wine with dinner. It was 45 minutes ago. I don't feel safe. I mean, that was an option. I don't know. Maybe if she had to go, I don't know what the solution is there. I do have a question though, and this has nothing to do with the case, but judges are on call all the time too. I hear all the time, oh, I was awoken at 3 a.m. to sign this warrant, and you're in jail now. Like that happens. They say that sometimes during arraignments the next morning. What if a judge was drinking and signed the warrant when they were hearing or reading? Can that be put into question? Now they're at home and it's probably over the phone or over a computer, so there's no way to know. But could that potentially be an issue?
Yeah, definitely. And the judges, there's magistrates that are like a judicial capacity that are typically on call. And so it's not necessarily the judges that are getting those 3 a.m. calls around here anyway. But yeah, if you are the magistrate and you're on call, you're expected to be safe, sober, and available.
And if I found out if I found out they were drinking, I'd 100% challenge that warrant.
Oh yeah, absolutely. Like
Yeah, and again, I don't know how that would come out. I mean, maybe if you signed a warrant at 1 a.m. and then you got a DUI at 2 a.m., I guess that would be pretty clear that you were probably drinking when you signed that warrant. I wouldn't know how that worked. It just jumped in my head when you were talking about it at all hours. All right. Again, didn't really have any bearing on this case, but thank you. I appreciate the insight.
crime happens any day at any time.
It does. It does. And that's why you need a lawyer like Rob to defend you.
Or just don't do the crime.
Or just don't do the crime. Yeah. That's the easiest way to not ever see Rob's face is just don't commit crimes.
Yeah, put me in immigration work permanently. That's
There
fine.
you go.
No comment.
For anyone, including a prosecutor, to have an alcoholic beverage with dinner if they're under the impression that they're not going to have to work later. I think the problem here was that after having that drink, or perhaps while finishing that drink, State's Attorney Bakos was apparently contacted by the state police and told, we need you to come back to this potential crime scene. And then she had a decision to make. And the decision she made reflects very, very poorly on her professional judgment. She could have, I don't know if it would have worked. She could have tried to postpone the walkthrough. She could have delegated to one of her deputy state's attorneys.
All right, just real quick. Neither one of you to respond to this, but I feel like everything we're saying is happening right before they're talking about it. So I
promise I did not watch this ahead of time.
No, it's working out perfectly. We sound really smart.
Yeah,
Great.
I didn't see this. So fresh takes.
she chose to go herself, even though she knew and publicly volunteered in the press when she was running for her public office that any influence at all from alcohol or drugs in relation to driving is a crime. So she
said that in relation to explaining why she wanted to divert cases like her own, like DUI ones, instead of she was talking about her platform of wanting to give leniency to DUI ones through diversion. Right?
Yes, that is correct. And that's certainly a reasonable position, I suppose, for a criminal prosecutor, an elected criminal prosecutor to take. But we're now in a completely different situation where when State's Attorney Vakos stands up before a judge or a jury in a
So,
Debbie,
Colin,
I am so sorry. I was
I was like,
refilling my
where
water.
are you? Are you taking a
Yeah,
break?
No, I literally.
You're not allowed to take breaks.
Every single time I have people on panel, there's always one time a stream where I'm refilling my water, and I hear,
Of
"Can you
course.
pause it for a second?" I'm like, "Dang it! It's gonna be like
Yes.
5 seconds."
I was like, I said pause, maybe. Rob, do you find it interesting that this justice is like challenging on behalf of the prosecutor, which is like the respondent in this case, with like information about her, like what her platform was that she ran on? Like, I don't know if any justice would know what my platform is that I ran on or what my reasoning was for wanting to say that, you know, any influence of alcohol or drugs is inappropriate. Does that strike you as strange?
It does, because it shouldn't be relevant to the analysis of, the ethical violation. At best, that's a political question that the court really shouldn't be determining about whether or not she's holding true to her platform or whether she's acting antithetical to it. Maybe it has some tangential ethics connection, but from what I gather here, the question is was there a quote serious crime committed or not by this DWI? So it does seem out of scope.
It caught me off guard. I mean, obviously we're on the back end of this, and they probably have all sorts of complaints and responses and discovery and briefs and all of that. So maybe she's just very well prepared for this hearing and has absorbed all those things.
She also seems to be the only justice that's really speaking anymore. Ever since we had, all three of them jump in right at the beginning, the other two just kind of stopped and let her take over. So
yeah, that is true.
DUI case, the question has to be asked in light of her criminal conviction for DUI, can she command credibility and respect from the jury, from the judge, from her fellow attorneys, and from law enforcement? And so that's certainly a relevant factor in terms of assessing whether this criminal conviction of this particular attorney reflects adversely on her fitness to practice law as a prosecutor.
I just had one. What Rule 8.4 makes reference, which I think everybody is using as sort of some of the case law under 8.4 as persuasive authority. And that rule talks about characteristics relevant to the practice of law in the comment. What characteristics do you think she lacks for the practice? What do you think? What characteristics would you name that she doesn't have for the practice of law?
Based on her conduct indicates that she lacks perhaps the most important characteristic for a lawyer, which is a willingness to abide by the law, uphold the law, refrain from criminal conduct. And so, as I stated at the beginning, I think that characteristic, that sort of adherence to legal obligations, both under the criminal law and under the professional regulation of lawyers, that indifference to legal obligation indicates a lack of a key characteristic needed by any lawyer to be a lawyer and to be fit to practice law, but especially so as a criminal prosecutor, as a lawyer who is publicly charged with upholding the law and enforcing the law, not breaking it.
But then every crime a prosecutor commits will qualify then. Is that your position?
Not necessarily. It depends on the crime and it depends on the surrounding circumstances. Now, for example, if State's Attorney Vakos had been arrested on suspicion of DUI, and if she had said, well, I maintain my innocence, but I'm going to let the legal process take its course. I'm not going to try to improperly influence two different state police officers and say, well, you could let me go, or you could call a friend to drive me home. She could have decided to in no way allude to her official position in the office that she runs and what effect her personal arrest will have on the relationship between that office and law enforcement. So if she had chosen differently, it's quite possible this petition would not be presented if it were simply a first-time misdemeanor DUI where there was no aggravating circumstances, no pattern of misconduct that would indicate her indifference to legal obligation.
Mr. Alexander, can I?
Hey, we finally have a new justice.
Hey, Adrian, weighing in.
Dan, I wanted to ask this question because I don't really know how these hearings work. So normally the hearings that I watch are criminal. You have a prosecutor and then you have the defense. But these type of hearings, you don't have that. So this Jay Alexander guy, so every time, the entire time, I've just wanted a steak, and it's like I really wish his name wasn't Jay Alexander because he's just making me hungry. But what position does he have? Is he a prosecutor? Are there specific positions in these types of hearings where they're the one who like kind of takes a prosecutor type role? And I don't know how better to ask that question.
That's what it appears from this. Like, I'm not sure what Vermont's setup is, but it appears that he is the attorney that is representing the disciplinary board who is asking for, I'm assuming they're asking to have her continue to be suspended from the practice of law instead of being reinstated. But it is like a prosecution type position.
Okay. Yeah, we haven't heard one word from David Slay, and I'm pretty sure that's her attorney. And
Yeah, with the beginning it said that was her attorney.
All right.
Yeah, so John Alexander, I just looked him up. He's the counsel for the Professional Responsibility Board for Vermont. So he's acting as the Professional Responsibility Board met and likely determined some sanction was appropriate, and so he's representing them in this proceeding before the Supreme Court. And then it looks like the other guy, David, whoever Shiloh, is going to be her attorney defending.
Okay, perfect. And they keep referring to this as a tribunal, so I'm assuming that means there's only 3 judges. And it looks like the 3 that are in the robes are Nolan, who has been speaking most of the time. Now we have Drescher, who just spoke up, and then the guy right above him, Priber, I'm assuming. I don't know. I mean, Nancy was speaking earlier in the video. I don't know who the Heaton guy is. Maybe we'll find out here shortly. That's my assumption of what's going down right now. And yes, I have seen this. It's just, I watch a lot of court and I'm not a lawyer. So I quickly forget and get confused on cases that I've seen before. You guys do this all day long, so you guys probably remember a lot more than I do when you watch a case. I don't have that memory.
Ask a question. Let's suppose I agree with you that she committed this offense while she was in the practice of law, while she was engaged in her duties as a state's attorney, that she tried to improperly talk her way out of getting charged, and that she then confirmed a few days later that it had impacted her ability to practice law in the form of the "I don't feel safe" email. Let's assume I agree with you on all of those scores, and as a result,
yeah, now the Heaton guy does look like he has a robe on. So is this are there 5 judges here?
Yeah, this is all 5 justices of the Vermont Supreme Court. Chief Justice is Paul Reber up in the upper left, and then Associate Justices Eaton, Waples, Nolan, and Drescher.
All right,
get the whole team together for this.
You do. I'm still waiting for David to say a word.
Conclude that this is a serious crime as defined in the rules. Let's also assume that she abides by her conditions of probation, and that in 3 months or so, her suspended sentence is up. Will she still be convicted of the offense in 3 months? And should we be considering that today?
Well, Justice Drescher, that's a fascinating question. In part, I think it raises separation of powers concerns, whether the statute dealing with expungement of deferred sentences, and I don't think the citation was given in respondent's brief, but I believe it's 13 VSA 7041. So that raises the question of whether a statute can somehow override or interfere with this court's plenary power to regulate the profession of law. But I think it's an interesting question that the court need not reach because as of today, State's Attorney Vakos is convicted of a crime. It's our contention it's a serious crime, and that triggers interim suspension under Rule 21. I think also it might be a bit speculative to talk about what might or might not happen in terms of expungement of the criminal conviction. Under Section 7041, the presiding court, the Superior Court, could find good cause not to expunge. And I think an argument could be made that good cause would be furnished by the fact that it's an attorney who's convicted of the crime, and that criminal conviction under this court's rules is relevant to discipline and interim suspension. But again, as I said, it's just a question that I don't think needs to be addressed to decide this petition. She is today convicted of a crime. It's a serious crime, and that warrants interim suspension.
I want to take you back. Can I take you back for a minute to Justice Nolan's?
There you are.
Yeah, I'm here.
So, okay, so just so that I can understand, so Rob, correct me if I'm not hearing this correct. Did they just say that she's on a deferred sentence for a DUI? Now, they said she pled no contest at the beginning, which I think is interesting in that in order for them to use that conviction for this circumstance, they would have to prove independently in this hearing that she did what they say that she did. But this is like what we use for domestic violence cases, where if you do a probation and you do certain classes and conditions and stay out of trouble, it can be expunged off of your public record. We don't have anything like that for OWIs. So that kind of circles back to what the justice at the bottom of the screen was talking about. I wonder if this is something fairly new that her office kind of spearheaded, and now she's using it. I mean, it's made for everybody.
Yeah. So what I heard earlier in the news story was she got a 6-month deferred sentence. So I imagine it's what we call like a stay of adjudication, where as long as you don't have any new offenses within the probationary period, the case gets dismissed. They also said that there's an automatic expungement. That's just what the justice was saying there. That is a little bit interesting because expungements, if you ultimately have a conviction that's entered, an expungement just changes the visibility of the conviction. It doesn't mean you were never convicted. So like if you had for firearms crimes, if you had something that made you a prohibited person and then you later get that conviction expunged, that doesn't actually retroactively change your conviction. It just changes the visibility of the conviction, so it doesn't necessarily restore your rights. So it is a little bit interesting there. I don't know if they're talking about the deferral, meaning that it ultimately ends in a dismissal and an expungement, or if it's still a conviction that then gets expunged. I don't think it functionally matters at this point, because at the time of this hearing is happening, she does stand there convicted.
It's interesting. It made it sound like if she stays out of trouble, obeys her order of probation, that after X number of months, it would be then like dismissed and there wouldn't be a conviction, and that we just don't have that for DUI. That's an interesting concept, I guess. We just, within the last few years, the expungement laws changed where you can take drinking and driving, certain ones you can ask to have it set aside or expunged off of your record, but there are very specific parameters for that. I guess it kind of blows my mind. There's this mechanism where you can just do your probation and stay out of trouble and then it goes away. So yes, maybe I'll have to look into
we occasionally I'll be able to do that if it's a first time low level not over 0.10, so kind of in that 0.08 to 0.10 window, I can generally get a stay of adjudication where, they're on probation for a year, they do all their programming, and then at the end of the year, it ends up getting dismissed. It's kind of a one-time thing because you'll never get that opportunity again.
Right. And I guess we've not had anything like that. It's more of a either we don't prosecute it and you're on kind of like a community program that it's still hanging over your head. So if you don't do what you said you're going to do, or you get in trouble, then they can charge it. But a deferred sentencing, in the sense that we use it, is okay, you admitted or the plea was entered, no contest or otherwise. And before judge decides what your punishment is going to be, we're going to set it out for this deferred period and then come back. And if you've stayed out of trouble, then maybe the typical 1 day drunk, 1 day sober in jail, we're not going to do that. Or, there's not going to be any further probation. You were on bond for this period of time and you did the treatment and you did the testing and, you've done all the things that we would have asked you to do on probation. So we're not going to then have you do a probation, which is expensive and time consuming. And but I've never seen it where it's dismissed. It's just very interesting. Learn something new every day, I guess.
Yeah. Sorry, I didn't know if Rob was going to respond.
But Colin, are you alive? Are you okay?
Yeah, no, I'm here. I'm trying to read Rob's facial expressions because generally I can tell when he has a comment or not, and that one was kind of gray area. I was like, is he going to respond? Is he not? So I didn't want to start talking, and then he was going to jump in.
Challenge me, Rob.
Good
Come
luck.
on.
Yeah, I didn't want to make the live last 3 hours, so.
Okay. What was our time frame we're shooting for here anyway? I don't know how long this was.
No comment on the time frame. We're having fun. So there's no time frame on fun, right?
Chief is making like the most obnoxious deep breaths and huffing as he's laying down here. Like, I don't think he's having as much fun as we are.
Yeah, well, I mean, he doesn't like it when I pause all the time for interrupting the video, so I understand.
Question about characteristics, I was surprised in your answer that you did not touch on judgment, because it seems to me that a lot of what you're arguing here is opportunities for Ms. Vacos to make different decisions, which she did not make. And the decisions that she did make, to me, reflect on judgment and ability to do the job by exercising proper judgment. Do you have some comment about that?
I totally agree, Justice Eaton, and I'm sorry I wasn't more clear, but I think I'll reiterate that State's Attorney Vacos' decisions to drive that night reflect very poor professional judgment, because she knew that she had just consumed a gin and tonic shortly before. We don't have in the record any sense of how much alcohol
we know what
was
she
ingested,
drank,
but we know that she finished it shortly before she began driving toward the potential crime scene in Bridport. That, knowing that she's going to meet with scores of law enforcement officers, many of whom are specifically trained in the detection of people under the influence of alcohol. So that shows poor choices, poor professional judgment, and that quite obviously is a key characteristic of not just any attorney, but very specifically a criminal prosecutor, because so many of the decisions made by criminal prosecutors are highly discretionary. And so the legal system, the legal profession, and the public at large rest on confidence that a criminal prosecutor will exercise good professional judgment in all cases. And given the criminal conviction, I don't think that the public or the bar can have a very high degree of confidence in State's Attorney Vacos' professional judgment. So that is another key characteristic that this criminal conviction and related misconduct reflect adversely on. And as I was indicating, there are other sort of more practical nuts and bolts characteristics of being an attorney who is fit to practice as a prosecutor, being able to zealously prosecute all crimes, including misdemeanor DUIs, being able to adequately work with and support victims of all crimes, including DUIs, working effectively with law enforcement. All those very practical and necessary characteristics of fitness to practice as a prosecutor have now been called into doubt very publicly by this criminal conviction and the related behavior. And so when a state's attorney who is charged with upholding the law has been shown to have broken the law, it reflects poorly on their professional judgment. It reflects poorly on their professional credibility and confidence to do the job effectively. So I think that the phrase reflects adversely otherwise, another characteristic, it's a catch-all term, but surely such characteristics as respect for the law, good professional judgment, good practical ability to do the actual job, there are all serious doubts about all those key characteristics as a result of this criminal conviction and related professional misconduct. I think that there is a somewhat of a paucity of case law from this court on how to deal with this situation. The closest fit, and it's not a great one, is the In re Warren case from 1995. There you had an attorney who, after I believe it was 4 or 5 DUI arrests, was finally convicted of a DUI. So there's the criminal conviction. And then you have the related professional misconduct. He appeared in court 5 times for clients under the influence of alcohol. Now, there's no indication from the In re Warren opinion that appearing in court for clients is a crime or was charged as a crime, but it's certainly professional misconduct. It's a lack of competence and diligence. It interferes potentially with the operation of a tribunal. And so there you had instances where if it had just been a single DUI conviction, the court may not have agreed with the PCB decision below that this reflects adversely on Attorney Warren's fitness to practice law, but coupled with the fact that he had been arrested before for DUI and had showed up intoxicated in court for clients on multiple occasions, that pattern of related misconduct was enough to support the conclusion that it reflects adversely on his fitness to practice law. And I think there is a related pattern of misconduct here with State's Attorney Vacos. And it's largely all confined to the night of her arrest, the decision to drive while under the influence, and then the decision to use her official position to evade responsibility for the consequences of driving under intoxication. It's all related.
How does that make a pattern? I think that's a little bit of a stretch.
I'm struggling with that too. It's like, okay, let's think about this. Like, if it's a one bad night, right? Is that a pattern? And if she was in fact intoxicated, she probably wasn't making great decisions, right? So once that first bad decision to drive, and then okay, you're intoxicated, you're not making great decisions, and you try to use your discretion or tell them to use their discretion. Again, do we know what her blood alcohol was or what she had in her system?
No, she refused all tests. They
didn't do a blood draw?
They didn't do a blood draw. They have no evidence of any type of alcohol in her system.
Well, how did they?
I don't know. She pled no contest. No idea. It's Vermont, so we don't get a lot of courts from Vermont, so no idea how this all went down. And I don't have the resources like you guys do, where you could probably go through and read all the notes and what happened. I don't know how to do that. I don't know if you guys can do that in other states, but yeah, I have no idea. But she pled no contest, no evidence of any alcohol in her blood. This hearing is less about the DUI, more about her using her position, though. I feel like that's what Alexander is mostly arguing.
The only thing I could think of they were talking about as a pattern is that subsequent comment about, I don't feel safe around the officers. But even then, that's a bit of a stretch. I don't think he needs to oversell it this hard.
Yeah, I feel like there was another comment when I was researching this. She made another comment, and I don't know if they're going to bring it up or not. I feel like they would have, where she kind of made fun of the police that work in her jurisdiction, and she did something about, she put a post on social media, and then someone responded, and then her response back was correcting their grammar. That was in the news when I was researching this, but I don't, looks like they're not going to bring that up. So it sounds like she had a bad week after this happened, but yeah, I don't know.
I guess I would not compare that to an attorney who had a DUI, showed up drunk to court, and then got another DUI, like in some, like that seems, that's a pattern.
That's a
pattern. There's an alcohol issue there. Whereas, you know, maybe she wasn't under the influence. Maybe if she would have just taken the roadside PBT or done something, she would have been like a .01, and there was no visibly impaired driving that was seen because she was parked there or whatever. I guess we'll never know.
Yeah, we'll never know. Rob would have got this thrown out for sure.
And it is all
Just
done
kidding.
in the course of her practice as an attorney and duties as a state's attorney. So, yes, I think that not every first-time misdemeanor DUI is going to reflect adversely on fitness to practice. In this particular case, it's our contention that it does. I don't know if I have any remaining time. I'd be pleased to take any more questions, or I could address some specific points made in.
I don't see any other hands. Anybody
It's
have
like,
any more
moving
questions?
Let's go.
Anything more, Mr. Alexander?
It's David's turn.
No, Chief Justice. Thank you.
Okay, let's turn to the Respondents' Counsel. Please start by introducing yourself and your client, and then proceed.
You're muted, Mr. Slay.
Yeah, great start.
Not a good way to start. That
Great
happens.
start.
He's been sitting there
thought
so
everybody
long.
would
This is
prefer
I
it
know,
that
right?
way. My name is David Slay. I represent Addison County State's Attorney Eva Vekos. I have really three points that I want to make. One, first time DWI, no accident, no injury, no property damage, no observed driving errata, does not constitute a serious crime, no matter how you look at it. It's not a felony. It's not of that group that we used to call crimes of moral turpitude. It's not a crime in and of itself that involves an interference with the administration of justice. Rule 8.4b says that in order to qualify under the interference with administrative justice provision, the crime itself must have an element of which involves interference with the administration of justice. DWI clearly does not. So one, I'm going to argue that it's not a serious crime. Secondly, I'm going to argue today that even if it is a serious crime, if this court determines that the circumstances indicate that a sanction will not likely involve any interruption of Ms. Vekos's ability to practice. Every single case that Mr. Alexander cited that applied to prosecutors wound up with a public reprimand as the only sanction. So to suspend her ability to practice law between now and whenever he decides to file a complaint before the PRB and after that process is over is simply going above and beyond what the end result would ultimately be.
Mr. Slay, can I ask you about that? Doesn't the rule state we shall order the suspension if we conclude the conviction is for a serious crime?
It may. I have to go look at it again.
Assuming it does.
Shall, may. Words are not that important, Justice. Come on.
Shall and may are two very important words in the law.
They are.
And when you're talking about this, that's something you should know. Like if it says if it's a serious crime, then the tribunal shall suspend. That's a non-discretionary language that they're being used. It's implying. Now, I imagine he's going to come back and be like, "Well, you don't have to listen to that," but.
He's not. It's not a serious crime. That knocks it out.
Yeah, if it was a serious crime, it'd be a felony, right? Let's go. Why isn't that your defense?
It is interesting because sometimes, like older states like Vermont, some of this language goes back to like the 1700s, when it was put in about, the disciplinary stuff. So it could be interesting about what was their idea of a serious crime there, and would this have been encapsulated in it? That might be an argument. Generally, all right, when in Minnesota's rules of professional standards, there's a kind of a lot of leeway for unethical conduct that leaves it up to the fact finder to try to determine whether or not it satisfied things. There's some things that are like immediately going to be suspension or disbarment, like misuse of client funds, things like that. That's going to be an immediate suspension, like no questions asked. But other things like, I would imagine a fair number of the attorneys here just got letters of reprimand, public or private, for similar conduct. But then the question comes: this is a prosecutor, elevated responsibilities, elevated duties. So there's probably an elevated expectation of ethical conduct there as well.
Yeah, they kind of touched on that right at the beginning of the hearing. But yeah, no, Vermont being an old state, yeah, no riding or no driving your stagecoach above a .4. You can't do it. We don't know how we're
The
gonna
horse
test
isn't
you on
drunk
that, but you
though.
can't do it. Yeah, right. We don't know. We can't test them. They might be.
How would we ever get discretion not to impose that suspension if we conclude that in these circumstances it's a serious crime?
Well, I assume that you have plenary power to do justice in your supervision of the lawyers under your command. And if it seemed that it would be a miscarriage of justice to suspend somebody's license when you know that the sanction's not going to involve a suspension, would be consistent with that authority.
But wouldn't that be prejudging what the ultimate sanction is going to be in light of, the several aggravating circumstances that Mr. Alexander has pointed out?
Well, I want to get into that because I think one of the third part of my argument is that this particular request for interim suspension is both tardy and premature. So that if there had been concerns that the conduct was such that the public's confidence and the court's confidence in Ms. Vekos' ability to practice was implicated by her conduct 2 years ago, that the request to suspend her license should have been brought closer in time.
Closer in time to the guilty plea or the adjudication of guilt?
Closer in time to the conduct.
We're here because of the conviction.
We're here because she's alleged to have committed a serious crime with attendant conduct that is said to aggravate her criminal conduct. So if the allegation is that she was somehow improperly trying to evade criminal responsibility by throwing her office around to intimidate police officers not to charge her, that's the conduct that I seem to see here is most worrisome to Mr. Alexander, that an allegation to suspend her petition to suspend her license should have been filed then. Now, I also think it's premature because for the very reason that you've suggested, that how do we speculate about what sanction's going to be? If you look at every case that Mr. Alexander cited involving prosecutors convicted of DWI, no one got more than a reprimand. So assuming that we look to outside authority to justify his various claims, that same authority would suggest that sanctions is a public reprimand. I'm troubled by this proceeding because it's sort of quasi-evidentiary. It seems to me that if you watch the videos, and I have some indication that there were members of the court that wanted to see those, it doesn't seem to me that it's credible to say that Ms. Vekos was making a full-throated attempt to evade prosecution by asserting the sort of power of her office. Do
you have any objection to us watching those videos, Attorney Slay? Do you have any objection to us watching this?
The short answer is probably not.
Play them. Play them. Spoiler alert: they don't play them, but I would love for them to play the full videos.
But that's what I'm trying to get at. Typically, what happens in a situation like this is there's a complaint filed alleging that a lawyer has violated the rules of professional responsibility. That is sent to a hearing panel. There's discovery, there's evidence, there's ability to cross-examine, there's ability to argue about what the impact of various aspects of the case were. The hearing panel deliberates, they make factual findings, there's a sanctions hearing, they make a recommendation, and this court gets a full factual record. What's happening here is you get told that Eva tried to get Ryan Anthony not to prosecute her himself.
Yeah, I don't believe that's how that works. I've got lawyers on panel, and they can correct me if I'm wrong, but pleading no contest, the judge just looks over the facts of the case and decides if you're guilty or not. You're still found guilty. It doesn't change the fact that you're guilty or not, but no contest, it stops liability, any kind of claims that come from that. Am I wrong, Rob, Debbie?
It can have an impact on civil liability because if you admit guilt, that can be used against you in a civil court. When we don't have no contest here, but we have similar Alford pleas and things like that, where you're basically conceding that the state has enough evidence to convict you of the crime, and you're accepting the penalty as if you were found guilty. So it's really a distinction without a difference as far as the criminal law goes.
Yeah, that's how I thought it was too. You're just better with your words.
A full-throated, emotional, heavy-handed way. If you look at the video, Trooper, I can't remember his first name's Ryan Anthony, Trooper Anthony, approaches even the driver's side. She hasn't driven away or anything. He says to her, look, we've detected odor of alcohol in your breath. Would you please step out of the vehicle? And she says something to the effect, oh, come on, Ryan, can you just have somebody give me a ride home if you're concerned? That is not a full-throated demand for leniency. That's like saying, hey, look, I don't think I'm impaired, but why don't there's a way to resolve this if you're concerned. Later on, if you watch the full 45-minute interaction with Detective Neary, Sergeant Neary, who does the processing, she says, and she looks like she's upset, emotionally upset, might be crying. Says, this is going to cause trouble for my office and law enforcement. Well, it's pretty obvious it's going to cause trouble for her office and law enforcement. She's the state's attorney. She's going to get prosecuted for DUI. Is that some kind of corrupt attempt to obstruct justice? I would argue not. I would say that if we had a chance to present this evidence in an evidentiary hearing following the rules of evidence with the impartial panel, the conclusions that Mr. Alexander are recommending would not be persuasive. And so what we've got here is this.
Can I jump in? I just want to understand, are you conceding that your client, as she was being processed, expressed concerns about the consequences of what was happening with regard to the future relationship between her office and law enforcement?
I wouldn't paint it that broadly. We have transcripts. I'm happy to send it to you. You can read the very words yourself. But she says something to the effect, this is going to be problematic. That's true.
And problematic in what sense? What did she mean?
Well, I think there's any different ways to argue that. I don't have the transcript right in front of me, but it's something like this is going to be problematic for me going forward.
Because she was the state's attorney?
Well, yeah, of course, right?
So how is that not relying on her position as state's attorney to try to affect what was going on?
She's not trying to persuade him not to do anything. She's stating a fact that this arrest is going to have ramifications, right? The prosecutor's getting arrested. If she stayed silent,
Yeah, he didn't see the same video we did at the beginning of the stream where she said she did kind of say that this is going to have ramifications. We're working on a good relationship between my office and the police, and you're just throwing that out now. That that was closer along the lines of what she said. Um, it can that be interpreted as using her position? Yeah. Do I understand what the her defense attorney's trying to say? Yeah, I see both sides, but uh, she chose not to go to trial. Like I don't. I feel like his points are kind of moot at this point when he's arguing this. Rob, I know you have something to say.
Yeah, well, he's doing his job here. He's trying to paint the facts in the light most favorable to his client without making misrepresentation. So he's offering alternative explanations from what we all instinctively took from those words. Not the most strongest hand to play, but sometimes you got to play the cards that you've been dealt.
That's fair.
Everyone would have to acknowledge that's true, right? This is a tricky situation.
What about her comment that she doesn't trust the police anymore?
Ooh.
Made 6 days later? Yeah. I think
Does
that
it
was
trust them or doesn't feel
problematic. She was
safe?
still upset. As you can recall, the last time we were here, when her license was suspended, she had to take a short leave. I mean, this was traumatizing. But look what she's done since, and then we get to the sanctions part. I mean, she gave Mr. Alexander every
Were those fingers you wanted to make a point, or were you just?
I was copying Rob. It was
Oh,
funny.
all right, all right.
I will say that I trust those cops more than the average police officer because they had the stones to go to take action on what they saw was a potential DWI driver, and it was a prosecutor in their own county, somebody who they have to work with. So I trust them more than the average police officer who may have just looked the other way. I commend them.
Right. They could have turned off their body cams and been like, I'm not doing this. It's tough.
That's a great point.
Tough to do your job when things like this happen, but you got to do it.
Yeah. Great freeze frame on Mr. Slade right now too. It makes him look really
use that
angry.
as your that needs to be a thumbnail from now on. Like,
yeah, there we go. I'll put his face instead of yours so we can stop having people accuse you of getting a DUI. How about that?
Perfect.
Aspect of her entire lifetime, medical records, mental health records, counseling records. She admitted to the civil suspension, saying that the choice she made not to take the test, which was her right, had consequences. Her driver's license was suspended. She completed the impaired driver's rehabilitation program and the attendant counseling sessions. She's executed her duties as a state's attorney in the intervening 2 years since her license was reinstated. I mean, again, that gets to where the sanctions are going to be.
Right, but does that, I don't think any of that pertains to whether it's a serious crime. I mean, I'm focusing on what happened in January of 24.
It's not a serious crime. It's not a felony. It's not a crime of moral turpitude. It did not affect the administration of justice. The Oliver case that Mr. Alexander relies on found that the DWI conviction of that prosecutor did not go to the fitness of that prosecutor's ability to practice law. And there's no showing in the interim, factual showing that this arrest has had any adverse impact on Ms. Vekos's execution of her duties as a prosecutor.
I was going to ask you about that. So the email exchange seems to reflect some disagreements about a number of things, whether it be, I guess it starts with a case intake disagreement and it carries over to grammatical problems with materials being submitted. So I wonder, was there any?
Yes, Yoder's every other Friday, free ice cream cones.
Yeah, right.
Grammatical errors. I just
If
heard the
that's
grammatical
happening,
errors you were talking
I
about.
need to know about this, okay? If that's happening, I want to know. I want to know where, I want to know when. I want to know that it's okay that we can do that. But, yeah.
Stoppage of her working with law enforcement. Did work effectively stop? in any way? I mean,
No.
aside from this email exchange.
No, there's a training that she didn't attend, single event. She took proactive efforts using the cooperation of the Attorney General's office for a period of time, have the Attorney General's office prosecute cases that involve Trooper Anthony, so there wouldn't be any appearance of impropriety. They worked out a protocol to address all of that. And since then, have you seen from the statistics, Addison County is operated right in the center of all the other counties. So there has been no breakdown. She hasn't been petulant. She hasn't refused to cooperate with law enforcement. To the contrary, that she's had consistent meetings with all the leaders of the law enforcement agencies in Addison County.
So,
Mr. Slay,
Mr. Slay, you made an interesting, thank you. Mr. Slay, you made a interesting comment early in your argument, and that is if Bar Counsel, or if Mr. Alexander, excuse me, was so concerned about the Ms. Vacos's continued ability to prosecute and act as state's attorney because of all these issues regarding her judgment and abuse of authority, then he should have filed the request for the interim sanction early in time in January to prevent her to prevent any more danger to the community as a prosecutor. And he didn't do that. He waited, but almost how many months later? 6 months later, is it now? I can't.
2 years.
Oh, 2 years. 2 years. That's right. 2 years later. And that's right. Because it was January in 2024. Right. Okay. All right. Thank you. Do you want to follow up on that? I'd be interested to hear anything else you might want to add to that argument.
I feel like she just wanted to say something on the record. I don't know what that just proved there, besides that she didn't understand the timeline. Okay,
here,
all right,
guys.
we're good now.
It seems to me that there needs to be a temporal connection if you really think somebody's trying to obstruct justice, independent of the DWI case elements, driving while under the influence, that if there was really a danger to the community by either her fitness to practice law or her interference with the administrative of justice, that needs to be addressed contemporaneously with the threat. Now there's been 2 years. Any perceived possibility of a threat or potential for a threat that you might have thought might be going on in January of 2024 never materialized. In fact, to the contrary, she's taken extraordinary efforts to try to make sure that Addison County runs normally as a law enforcement agency and a prosecutorial agency.
But Mr. Slay, isn't Justice Drescher correct that the triggering event here for what brings us here today is the conviction? And I'm looking specifically at Rule 21B, which says that upon being advised that a lawyer subject to the disciplinary jurisdiction of the court has been convicted of a crime, the disciplinary counsel shall do such and such.
Of a serious crime.
No, it says convicted of a crime, not a serious crime. The crime is a triggering event to determine whether it's serious or not.
Right. If we're talking about the commission of the crime, the elements of that crime are uncontested, right? She's been convicted of DWI. Nowhere, and I've looked as every single published PRB and PCB opinion that I can find online, nowhere has this court found the conviction of a single DWI to constitute a violation of the code. Not ever.
Do you have any problem with us holding prosecutors to a higher standard when they commit criminal offenses in this context?
I saw both of you perk up real quick. Like, I think that's the question that we've all been wondering about. They said that, like, hey, should we do this? Should we not? And now we actually have the question to the defense attorney. Let's go.
No, I don't actually. But whether that standard, so in my pleading, I noted that the ABA found that a majority of American jurisdictions don't treat a single DUI as an ethical violation. Some say that while it would not be an ethical violation for non-prosecutors, it may be for some prosecutors, but in those
We're not talking about the DUI. We're talking about what she did, how she conducted herself. The DUI has already been proven. Like, he keeps arguing the same point.
But I mean, they
All right.
But
are
I think
actually like they're only here because of the DUI at this point. Like the conviction entered. So everything else is kind of non-issue is what it seems like, but Mr. Alexander was bringing it in as an aggravating factor of the DUI.
Yeah, I think, because the crime that they're talking about, the only crime she's been convicted of, it hasn't been misuse of a public office or anything like that, is the DWI. So I think that's the narrow scope that they're looking at, is in the totality of the circumstances, does this DWI qualify as a serious crime that would mandate a mandatory suspension?
All right. So if she wasn't, let me ask this: if she wasn't on her way to or from a crime scene, and she just went to a family dinner and had a glass of wine and got pulled over for a DUI on the way home, would we still be having this exact same hearing?
It, potentially not. I think it is the totality of the circumstances. I would not have conceded that point that he did there. I think that was a weakness on his part. Not that I necessarily believe it, but if I was advocating for a client, I would have said like, oh, well, no. I mean, it's fundamentally unfair to hold a prosecutor to a different standard for the same crime committed by another attorney. That would have been my argument. I'm kind of surprised he conceded that. But I think that what they're focusing on is in the totality of the circumstances, because I'm gathering that whatever a serious crime is, there's not like a specific definition within the rules of professional conduct for Vermont, because if it had listed off specific crimes, then this conversation would have been very short. So I imagine that there's a lot of discretion for the Supreme Court here to determine whether or not something is or isn't a serious crime. So in that sense, all of these ancillary facts about the way that the DWI had impacts beyond just the normal attorney are things that are going to be considered for the seriousness of the crime.
I like that. You should probably have a YouTube channel. Oh wait, you do. Rob has a YouTube channel. Everyone go subscribe to him.
How do you have time?
I really don't do that much content. Actually, my paralegal, Cass, is in the comments too. Cass does courts. If you want spicy Supreme Court breakdowns, definitely go give her channel a follow.
Oh, awesome.
Nice.
Awesome. If one of my mods can find that channel and post it, that'd be awesome. What is the channel called? Cass Does Court? Is that what you said?
Yeah, she's been in the comments. Cass does courts, and she covers all the hot button Supreme Court cases, breaks down the oral arguments. She does a great job.
Awesome. Cass, can you say hi real quick? Because one of my mods can click on your name and go to your channel and then post your link. Oh, nope. I think someone's already found you. Well, Dan already found you. Yeah, it's Dandolph. Dandolph knows everything. Before I hit the play button, can I just I'm gonna pat myself on the back for every time I hit the pause button. Mr. Slay looks like he's he's really into what he's talking about. Yeah.
Mean. It's just mean.
But he hasn't. Every time I pause it, he looks like he's yelling. He's been very calm this entire time. But I don't know why his facial expressions make him look so upset.
Cases, in every one of those cases, the sanction was a public reprimand. And in fact, the one case that Mr. Alexander relied on that actually addressed this question about whether a DUI conviction was justification for an interim suspension, the Oklahoma court said no, even though it was the second DWI conviction of that particular prosecutor. So while it might be a higher standard, I mean, look, those of us who have been around for a little while probably know a few lawyers who've been convicted of DWI and have never had a conduct complaint filed against them.
In those instances, the attorney's crime presumably did not happen while she was actually performing professional duties as an attorney. And she probably wasn't a member of the law enforcement community. And they probably didn't create a record that could be construed as trying to exert the influence of her position to try and affect the proceedings.
But that doesn't change what I'm telling you. So other lawyers who get convicted of DWI, whether they're on their way to court or on their way to a softball game, never have conduct complaints filed against them. If a prosecutor does, they get a conduct complaint filed against them. And I think that's legitimate because there's a higher standard. Does that mean that because of that conviction that they're subject to an interim suspension of their license? The answer should be no.
Thank you, mods. I appreciate it.
No.
All right. Anything more? Mr. Slave?
No, Your Honor, but we would like an opportunity before there's any sanction imposed to have a complaint filed, to have it referred to a panel, to have the due process necessary to actually litigate whether these utterances were, in fact, illegitimate attempts to avoid prosecution. My view, if you look at those utterances, is that the conclusion is that they were not. And I don't think it's in this sort of quasi evidentiary proceeding, where in essence, this is like a Rule 5 proceeding where it appears the court is willing to take Mr. Alexander's assertions in the light most favorable to the state and exclude any modifying evidence. We don't have a chance to put on a defense here. It's not a serious crime on its face. There should not be an interim suspension.
Okay.
Mr. Chief Justice?
Yeah, please. Yeah.
Thank you. I just wanted to apologize to attorneys Slay and Alexander. I was losing connectivity, so I did choose to turn off my camera. I have been present throughout the entire proceedings.
Thank you, Justice Waples.
Making that record.
You got to make that record, yeah.
Reminds me in law school when I would ask a question that I knew the answer to just to make sure I got participation points.
Yeah, I feel like that's exactly what he's doing. Wait, when did this happen? July? January. Oh, Ron J month. Okay, what year? Oh, 2 years ago. Oh, that wasn't.
Yeah. So again, I didn't realize until this last kind of exchange, there's been no due process to her, no adjudication of whether this behavior, it happened the way that they're saying in the context that they said, and B, if so, if that affects her ability to practice law. And they haven't done anything about this, and it's been 2 years. And they waited till a misdemeanor, no contest, enters on a deferred sentence that sounds like it's going to get dismissed if she stays out of trouble. I'm going to guess if she's stayed out of trouble the last 2 years since the initial incident, she's probably going to be just fine on probation, right? So I get that it sounds like their requirement is to report this, and that once it's reported, this panel then decides whether or not it's serious enough to justify, oh my gosh, we need to suspend this person's ability to practice law because this is such a serious crime. Like, this seems wild to me that they're having this long of a hearing without any actual like sworn testimony or admissible evidence that has been presented. Like this is crazy to me.
It's a quasi evidentiary hearing.
Yeah, it is a quasi evidentiary hearing. So, and it sounds like, I guess, Rob, did you catch whether or not she was suspended? She was suspended from the practice of law for some period of time.
Three weeks. I just looked it up. 3 weeks because she was not complying with medical examinations. So then once she got the medical exam, she was reinstated. So she was only temporarily suspended just on a kind of a technical violation for 3 weeks. And then now they're seeking an interim suspension while the actual merits of the disciplinary actions go through.
So that is
So
even more bizarre to me than, because it's like, if you thought she was that bad and shouldn't be in the position that she's in, and then you didn't do anything for 2 full years, like, her attorney made that point, and it kind of resonates.
Yeah, I
If
think it's
she's
the
not have
strongest
any
one because
complaints filed, like, there's been nothing else
yeah,
filed, right? Like, she hasn't been making poor decisions or acting out of character for the last 2 years. It makes no sense why you would summarily, cut her off from practicing law or running an office just because
well,
a misdemeanor
yeah, it's
entered.
seemingly I doubt that like prosecutions have halted in this jurisdiction. So apparently
Right.
there's been some way that things have been able to be worked around. It just seems like that would, all the bad behavior notwithstanding, it does seem like it's a little bit late to try to be saying that, a suspension is necessary.
Right.
So this
Like,
is actually the second disciplinary hearing over this prosecutor. As Rob, you just said, she was suspended for 3 weeks a year ago. There was a disciplinary hearing then. Because she left office for medical reasons, as you just said, and I don't remember exactly all the details, but she left for medical reasons during this DUI, everything that's going on with this case, and the people were asking like, "What's your medical reason? Why are you leaving? Why are you unfit to be a prosecutor right now?" And they came in like, like she left for medical reasons. She doesn't have to disclose that. So there was another hour-long hearing where they argued about if she has to disclose her medical reason for being unfit to be a prosecutor during that short time. So that might have been around the period where she was suspended for 3 weeks. But it was boring. It was just they were arguing medical things back and forth, and so I didn't want to subject you guys to that. It was pretty boring.
appreciate
But yeah,
that.
that did happen about a year ago, which, like I said, Rob, that's probably what you were referring to, which is interesting. They're not bringing that up at all.
Okay, so if that happened only a year ago, but the DUI itself was 2 years ago, like,
I might actually still have the video open. I was just watching it before we started. I don't.
and
I
I
was
guess
gonna say,
it just makes no sense to me. Like, if you thought she was that unfit to practice law that an interim suspension should enter, then that should have probably been addressed back in January of 24.
Yeah.
yeah, yeah. I'm gonna let the video play, but I'm gonna look up the video and tell you exactly when that hearing was. So at least we'll have a date for it. Because I don't know. I'm just guessing a year ago because it was a little bit ago, but I don't know. Maybe it was a year and a half ago. I don't know. But I'll find it for you real quick.
Mr. Alexander, anything more?
Well, thank you, Mr. Chief Justice. If the court were able to indulge me, I'd address a few of the points made in respondent's presentation, but I don't. If the court already has enough for today, I'm happy to simply request an order of interim suspension and leave it at that.
Wow.
Well, why don't you? We'll leave it. I'll leave it up to you. If you have something more to say, please go ahead.
He seems very confident
I
that
would
he's
make
going to
a
get
few
this.
points that sort of one point made by respondent's counsel was that speculation on the possible or likely sanction in the future in a disciplinary proceeding before a hearing panel of the PRB. And that just under the plain language of Rule 21 is not a relevant.
All right. Sorry to interrupt during closing, but March 20th, 2024 is when that hearing happened. So the
Okay,
DUI
so
happened
then,
that January. So about 2 months later, that hearing happened.
and they did not find reason at that point to enter an interim suspension because she was so unfit, or the concern was that she was so
Well, I
unfit.
think it was a different concern at that point. I think it was the fact she was taking medical leave without providing an explanation. So I think she must have really pissed off the Professional Responsibilities Board. They must not like her because that sounds like a different allegation that they were bringing forward at that point. Am I right, Colin?
Yes.
Colin, I feel like you've tricked me. You tricked me into being a part of this. I was like, oh, no, my phone. Oh, I'm dropping my phone. You tricked
I would
me.
love to know how I tricked you.
Oh,
Are you just really invested now and you're
yeah, we'll talk about this later. We'll talk about this later, but off the live stream, maybe we'll have Rob and you and I can have a little chat.
all right? Well, we've only got about 5 minutes left. We can talk after it's finished. I didn't
Perfect.
trick you. No, I didn't have any dirty tricks. I promise.
Uh-huh.
I'm sorry if you think I did.
You're good.
Consideration in determining whether State's Attorney Bakos was convicted of a serious crime. If the court wanted to be a pertinent consideration, it would have written the rule differently. I don't want to get too much into the analysis of sanctions because I think it is premature, but I suffice it to say, I do think that this will ultimately, when a hearing panel looks at the totality of State's Attorney Bakos's professional misconduct, it will not give her a mere reprimand. It will be a suspension. Another point to make, and perhaps it's an obvious one, is that an order of interim suspension is not a sanction. It's not a punishment. It's merely an order to essentially protect the public. Well, really, when one looks at the text of Rule 21, unlike the Rule 22, which provides for interim suspension based on threat of harm, Rule 21 does not condition the issuance of an order of interim suspension in any way on harm to the public. It's really more premised simply, was it a serious crime or not? And so I think that Respondents' Counsel is really objecting to the process rather than sort of the merits of whether or not this is or is not a serious crime.
Okay.
But that is one final point that I wanted to make.
All right.
And I'll leave it
All
at
right.
that. Thank you very much.
Okay. Any questions from the panel? Any remaining questions? Then please call the conclusion of the hearing.
All right. We'll call a conclusion of the hearing. That's it.
They don't make a decision?
No, they don't. I've never actually seen a decision on any type of these types of hearings I've ever watched. There's never a decision
Yeah,
on
it's
YouTube.
always taken under advisement.
It's such a letdown.
It always is, and I'm gonna get a lot of people. You're gonna read the chat right now. They're all gonna yell at me. I always get yelled at for it. It just happened 2 days ago. Well, it happened Friday, I think. I think this was Friday. So yeah, even if I could look it up, they wouldn't have a decision already published about it. Anyways, yeah, that's it.
It just seems okay. So, final words. This hits close to home, Colin. Allowing a single person or even a panel of 5 people to make the ultimate decision on this when it's a factual question concerns me. Like, there's been nothing sworn under oath. There's been no evidence presented. There's been no opportunity to explain. And they're just going to take away this woman's livelihood and potentially ruin her reputation. Like that's crazy to me. And I don't have anything else to say, I guess, at this point.
I will tell you that I now know what you were referring to, and that was not on purpose. And
No, I
will
didn't
tell you
think that it was. I didn't think that it was. It was just, yeah. As this was going through, I was like, oh, this is familiar.
I should have thought better about that.
No, you're fine. No, you're totally fine.
Now my worst thought isn't the thumbnail anymore. Rob, what are your final words? You have no idea what we're talking about, Rob, which is good.
I don't.
I think 99% of people don't know what we're talking about. But
I mean, Google my name, right? Like, figure out.
I'm picking up the pieces. So, but I do know that certainly Colin never would ever intend any harsh treatment or anything like that.
I feel like it was like redemption for me. I could come in and say what I wanted to say. I like it. I like it a lot.
Well, that makes me feel better. I'm glad you feel that way.
So yeah, I mean, I share some of the same concerns. I feel suspension of an attorney's license is essentially, taking away their livelihood, and that's usually only reserved for very serious things, serious occurrences. A prosecutor is held to a higher standard, but they're also generally elected officials, or they work for elected officials. So there is some sort of political accountability that can happen with that as well, outside of what happens with their licenses. I do think it's important for people to realize that there is no sworn testimony here. This is just a assessment of whether or not the alleged actions reach the level of a serious crime, which apparently is undefined under the rules of professional conduct. So the Supreme Court here has a very large amount of discretion. Now, what you call a serious crime may not match the history of how it's been applied. I remember I just read a couple months ago, the Supreme Court of Minnesota issued a disbarment, which is very rare, and it was a one-sentence disbarment letter that said disbarment is the appropriate remedy for a attorney who is convicted of homicide.
Well, yeah.
Right. I don't think that
Not fighting that one.
I don't think there's any wiggle room in that one. But in things like this is there needs to be a full finding of the facts, and there needs to be an opportunity to present both evidence for, and then evidence that mitigates any of the seriousness of the crimes, and that didn't really happen here. So all we're looking to see is the conviction as charged meet that threshold. And I have some severe trouble with the timeliness of this. Clearly this prosecutor's been able to work in her job, finding a way to work. And I think I heard the attorney Slay say at some point that their convictions and their prosecution rates are at par with other counties. So that shows me that it's not like they're being shackled by this allegation of this professional conduct. So I have some heartburn trying to bring forth this action at this point.
So I will say a couple more things, I guess. So what's interesting here is the disciplinary panel that is represented by Mr. Alexander. He is using a no contest acceptance of like a punishment, right? And the punishment in this case for her is for the DUI. She never admitted that she was drinking and driving, or that she was impaired and unable to safely operate a motor vehicle. But if this had been dragging on for 2 years, the expense, the mental toll, the emotional toll of having to deal with that, she may have entered the no contest plea to end it, to limit the consequences and say, you know what, I can do a probation. I'm not going to get in any trouble. If it's going to be dismissed off my record when that end of the 3 months or 6 months or whatever it was is over, sure. Like, let's get this over with instead of spending thousands and thousands and thousands of dollars in legal fees and having it continually in the news and taking away from what you should be doing as your elected prosecutor. So now for the board to bring this back up and act like this is an emergent situation and try to use the conviction, they can't use the conviction without having some sort of evidentiary finding that the underlying acts were in fact done by her. So right now, they can't even use the DUI because she didn't admit to it, if that makes sense. Like, maybe I'm not explaining this.
Admit to it in the I mean, there's the things that we heard.
Yeah,
so
she
there's
didn't give a factual basis. Like, she didn't give a factual basis. She made no admissions, because a no contest is typically based on like the affidavit of probable cause or something like that. And if the affidavit of probable cause is just like, there's no like blood alcohol level or anything either, like this is very interesting.
Well, and
to me.
admitting to
I
having a
don't need
drink
more
isn't the
work to
same
be
thing as
looking into.
Yeah, admitting to having a drink isn't the same thing as admitting to have been intoxicated. So, there's definitely a lacking factual basis on here.
And then in addition to the lacking factual basis of the underlying crime that they're using the conviction for, the aggravating factors, those have not been admitted to. Those have not been proven. It's just, I can see why her attorney was getting frustrated and seeing this as like it's premature, but it's also tardy. When he said that earlier, I was trying to figure out like, what is he talking about? Like it's premature, but also tardy. So yeah, it's tardy in that if you really thought she was not capable of conducting herself in a manner as a prosecutor or an attorney
Why'd you
of
wait
any
2
sort,
years?
then why did you wait 2 years? And it's premature in that, okay, so you waited 2 years until she finally said, I'm done. I just, no contest. And sure, I'll take my punishment. But you are prematurely now saying, well, we think that this is serious and should suspend her license without allowing her the due process of going through the entire disciplinary portion of it now that the criminal portion is done.
I just
So-
connected so many dots with what
I
you
know.
just said.
Why did you do this to me?
Yeah,
Was this fate? Was
oh
fate?
my gosh, like this.
No, I feel really good about this right now.
Well,
Okay,
all
Logan.
right. All right. Well, I don't. I do not feel good about this at all anymore. I absolutely loved this stream until about 10 minutes ago when I realized the position I just put you in, and I am
Yeah,
so
you're
sorry.
fine. You're fine.
All right. That being said, Rob, you got anything else to say?
Yeah, Rob, what you gotta say?
Nothing. Nope. I'm done. Bye.
Yeah.
It's been really fun, you guys.
Well, thank
Due
you,
process.
Rob.
That's all I'm saying is
And
like due process, right? Like defense or prosecution, you have to give people the opportunity to have adequate due process.
yeah, yeah.
My 2 cents.
And I appreciate you, Jay Sense. I've got one super chat, and then we're gonna call it a night. Bill, thank you so much. Bail money for Colin. Yeah, yeah.
Only if you live in Joseph County. Just
I'm
kidding.
I'm gonna go to St. Joseph County, and then somehow I'm gonna get found in contempt. Debbie's gonna be sitting there like, ha ha.
No, not at all.
All right, all right. Rob, Debbie, thank you so much for hanging out with me tonight. I do
Yeah,
appreciate
it was a lot of fun. Thanks for having me.
It was a lot of fun.
Rob, it
And
was nice
thank
to
you.
meet you. I'm sure our paths will cross again.
You as well, Debbie. Thank you.
Thank you for everyone that hung out with us as well. All the super chats, gifted membership milestones. You guys are awesome. Mods, you worked overtime tonight. I do appreciate it. I know we're at 2 hours and 15 minutes. Super long stream tonight, but you guys are awesome. Thank you so much for hanging in there with me. But that's it. That's all I got. I will see you guys tomorrow night for our Members Monday, and then Tuesday night for back to the regular scheduled program. And that's all I got. So we're gonna peace out, and yeah, see you guys tomorrow night. Hold on, I gotta remember buttons. Got to do this one, then this one.